610 WTVN.
On the LegacyRetirementGroup.com phone line, we've talked to him before. Great information from the patent professor. It's John Rizvi. Good morning, John. How are you, sir?
Yeah, good morning. Always a pleasure to be here.
Yeah, I'm glad you're able to carve out some time for us. We appreciate it. So, as AI becomes more and more a part of our lives, like it or not, it's a reality. It's coming. This never occurred to me, which is why you're the expert. The U.S. Patent and Trademark Office has some new rules involving AI. So you can't just use AI to develop a product or a service and then go ahead and patent it now. There has to be more of a human element. Break this down for us.
Yeah, so it's not a new requirement, but because the Constitution requires a human inventor or author. So authorship or inventorship has always been required a human input. And as far back as the 1800s, there's a Supreme Court case where a photographer that, used a camera for a photograph. And the question was whether the camera is the author or the photographer. And it was held that the photographer, because of his input and the creativity involved, and there was enough of a human element, that the camera was just a tool. Now, come forward, 100-some plus years, the problem is the tools available for inventors and authors continuously get more and more sophisticated. So AI for an artist is not like a paintbrush for a painter or a chisel for a sculptor. It is so incredibly powerful that the human element involved in the creativity continues to go down while the input from the robot or machine or computer software goes up. And that's really the conundrum that the Patent Office is facing and the Copyright Office is facing. So President Biden issued an executive order asking for the Patent Office to publish guidance for inventors. And unfortunately, the guidance on what contribution is enough is that it has to be a significant contribution with really no definition of how much significance is significant, right? So how much input does the human have to have? That question still remains unanswered.
So I've got, if I've got a camera or a paintbrush and I'm using that as a tool, I get that. That's an extension of me. But when you're using AI and maybe you're just asking AI to, hey, write a children's book for me with these parameters, that's not a ton of creativity coming from the actual human being.
There's not, and there's been a few cases where there is an easy way to put the human being into that final product, and that is for post-editing work. So if you ask AI to create an artwork or a book or a story, and then you go back as a human and you edit that story and you make changes, then you've got a pretty strong argument that you've got a significant contribution. The problem is if you don't have that post editing work done and you're relying on exactly what the computer spit back at you, then they're going to look at the prompt and look to see if the prompt you entered was a significant contribution. And I think that's going to be a tough standard to meet.
So when considering, allowing a patent, the U.S. Patent and Trademark Office, how are they going to prove that this was a human piece of work versus an AI piece of work?
Yeah, so the technology has not gotten sophisticated enough to where you can prove, there's no detectors for inventorship to show whether AI has been used. Now, for written material, there's a bunch of software out there that, there's questions as to how reliable it is, but there's certainly software that can help detect whether something is AI written or if it's written by a human being. Now, that software can be tricked, in a sense, by post-editing. So you could use AI to create the original piece and then edit it, and then the software may not be able to detect that it was used. But unfortunately, there is no way for the Patent Office to actually police and see if AI has been used for the creation of an invention.
And so, are there any cases like this that are pending right now, as far as someone using AI to create a work of art or a product or a service that's being questioned?
There are not cases that are pending, but there was an inventor, Stephen Thaler, whose U.S. patent was denied because he listed the inventor as AI. So, the question remains, what if he didn't reveal that? His patent likely would have been approved, but he was upfront, revealed that the idea was done through AI, and the patent office rejected the application, as they had to do, because under the U.S. Constitution, an author or inventor cannot be a machine or computer or software. It has to be a human being. In fact, several years ago, there's a copyright case. It's known as the monkey selfie case, where a cell phone was picked up by a monkey. The monkey took a bunch of photographs. They went viral, became valuable, but the owner of the cell phone was not able to get copyright on it because he was not the author, and the author supposedly was the monkey that took the photograph, and the monkey's not a human. So neither can monkeys get rights to intellectual property, nor can robots or computers. And the Patent Office, if you list the inventor as anything other than a human being, the patent has to be denied and will be denied. The Patent Office made that clear.
It's fascinating. John Rizvi, the patent professor. John, I had a story earlier this morning about the inventor of karaoke. Just passed away. It's a gentleman from Japan. He was 100 years old. He invented what he called the Sparko box in 1967. It was the very first and very rudimentary version of the karaoke machine. He never secured a patent for his invention and likely lost out on millions and millions of dollars. So if you have an idea, how important is it to get it down on paper and get it patented?
Yeah, so incredibly important. In fact, it's always been important to get the patent filed. But as of 2013, the U.S. patent system changed from a first-to-invent system to first-to-file. So no longer is it enough to prove that you're the first to invent something. Now it's critical that you file the application first. So it's even more important today, if you have something new, to get that patent application in before anybody else.
Is there any way to prove, before I actually legally went through the proper channels and filing for the patent, that I had the idea first? Does that hold up anywhere?
No. Nope.
Okay.
In fact, the United States was the sole country that was on a first-to-invent standard. And until 2013, if you could still prove that you were first to invent, you had a fighting chance. But today, throughout the world, everything's gone to first to file, and that whoever files first owns the idea. That's been kind of at the detriment of individual inventors and small businesses, because they don't have the resources that large corporate giants have to get the patent in first. So this does hurt the individual inventor, because now you're under the same standard to first to file as Motorola or Google or Apple or Facebook, and it's not as easy for an individual inventor creating something in their garage to get the patent filed as it is for an engineer at Apple.
Sure. Makes perfect sense. John Rizvi, the patent professor. John, you got a couple of books out and a website. Where can people find out more about you?
Yeah, so our website is thepatentprofessor.com, but that's our handle throughout social media. So if you go to Instagram, Facebook, TikTok, and you type in The Patent Professor, you'll find us.
Very good. Thanks for the time this morning, John Rizvi, the patent professor. We'll talk again soon.
News Radio.